Let's get to Misty Marris, who is also watching this along with us. Just your takeaway from what you heard from the judge. This is obviously a routine thing, but there is nothing routine about seeing a child in this position and knowing that he's accused of taking other children and teachers' lives at this young age and charged as an adult.
Absolutely. And when you see this 14-year-old sitting there behind the defense table, it's just truly stunning. But what we saw unfold in the courtroom, we saw what is a procedural hearing, but as you stated, Sarah, nothing mundane about this one. So what did we learn? We learned that he has defense counsel. However, it sounds like for some reason, maybe there's a conflict of interest, something of the like, defense counsel is going to be replaced by the end of the day. The judge asked if there was going to be an application for bond. That would be some form of release, requesting release from the defendant. The defense attorney said no. That means that he will be remaining in a juvenile detention center, even though he's charged as an adult in Georgia from the ages of 13 to 17. Any time served takes place in a juvenile detention center because of his young age. So he's going to remain there. The next thing we heard was that he has the right to be indicted by a grand jury or to have a preliminary hearing. We know this is a basic tenet of the criminal law, that you have to be formally indicted in some way, the standard being probable cause. Sometimes defendants waive that. In a case like this, we could see the defense actually waive this and say, let's just move on to trial and assess whether or not there's going to be a plea deal, not guilty or guilty. So that's the next step. A preliminary hearing is like a mini trial. That's why we heard the judge set forth all of the rights that the defendant has if this were to go to a preliminary hearing, that there would be the opportunity to cross-examine witnesses and the opportunity for the defense to testify. Now, we heard the judge ask a few questions in the beginning. One of the reasons we're dealing with a minor here, Sarah John, this is what we were speaking about before. We have someone 14 years old, and although he's represented, he's technically under the law not competent to make his own decisions. And I'm not talking about competent in the layman's term, just that children are not able to enter into contracts. They can't make legal decisions for themselves. In a situation like this, since his father is also facing charges, we don't know about the status of his mother, whether or not she's going to be involved in his trial. Sometimes there's what's called a guardian ad litem, who is appointed to oversee the case and help a minor make these determinations. We also did not hear, and I would expect this to come at some point, a request for an independent mental health evaluation. In cases where you have just the most horrific facts like this, a mass shooting, a defense attorney is going to say this person should have a mental health evaluation to determine whether or not there's potential defense or whether they're competent to stand trial. So those are all the issues we would expect to see moving forward.
Misty Marris, our thanks to you. Again, we still have our eye in that courtroom. They are in recess temporarily.